Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now, take a look at this. Ripple versus SEC case, the legal battle approaching an endgame. With the submission of the final reply brief and accompanying exhibits by the SEC, it is anticipated that the current court battle between Ripple and SEC will come to an early conclusion. Since the 8th of May, 2024, the case between Ripple and the Securities and Exchange Commission, SEC, has reached the finalization stage since the SEC has just recently delivered its final reply brief. To decide the appropriate redactions, all parties will meet for the final time to discuss the submission, which is considered confidential. The SEC has submitted their last brief in the Ripple versus SEC case. With the submission of its concluding answer and supporting documents, the protracted legal battle between the United States Securities and Exchange Commission and Ripple is set to come to an end. On the 8th of May, Times Tablet announced that the final reply brief regarding the Ripple versus SEC lawsuit had been submitted. At this time, the specifics of the document released by the SEC are being kept under wraps. However, a version that has been redacted is planned to be made public on May 8, 2024. Before this happens, Ripple and the SEC will work together to remove any sensitive information from the document. Does this mark a significant change in Ripple's legal case? In its preliminary brief, the Securities and Exchange Commission called for a penalty against Ripple that was close to $2 billion. The SEC cited the company's sales of its native token XRP institutions as a violation of federal securities regulations. Additionally, Ripple claimed that the proposed punishment was exorbitant and instead offered to settle for a sum of money that was no more than $10 million. In addition, legal professionals anticipate that the SEC's final report would address Ripple's counter-arguments to the agency's initial suggestions for remedies. If the final verdict is appealed, the case could be extended until the year 2025. By December 2020, the Securities and Exchange Commission, SEC, had launched a lawsuit against Ripple Labs and its management, accusing them of breaking federal securities laws and acting illegally in the cryptocurrency industry. Additionally, the company was accused of utilizing a security that was not registered to generate funds. The well-known cryptocurrency influencer known as Metal Wayman, who has been active on Twitter as of late, has thrown light on the SEC's lawsuit against Ripple. In particular, he has focused on the SEC's recent filing about damages and disgorgement. He made the argument on X that the Securities and Exchange Commission has not contributed anything convincing to the discussion on victims or the reasons why disgorgement ought to be the preferred remedy. According to Metal Wayman, the Securities and Exchange Commission, SEC, primarily depends on a single district court judgment known as SXCVI IFRESH. This case established that the pecuniary harm threshold is satisfied when an artificially inflated stockholders' investment is made. This is the viewpoint of the Securities and Exchange Commission issue, as states that those institutional buyers who paid a smaller discount for XRP than others are the ones who suffered an inflated price, which is a clear indicator of monetary injury. This is because the inflated price is a clear indication of inflation. On the other hand, Metal Man voiced uncertainty on the accurate interpretation of the facts of this case, stating that it was a misinterpretation of the remark made by the Second Circuit in the case of Second v. Salvo, while pointing out that the judge who produced the IFRESH ruling labeled it as Metal Wayman observed that the SEC's reliance on IFRESH as precedent for establishing pecuniary harm raises concerns. In addition, he was quoted as saying, in the past, it was considered inappropriate to mention a ruling that was designated as not for publication. It is the most tenuous authority that could exist for anything. Justification proposed by the SEC for disgorgement. The complaint that was filed in the court by the Securities and Exchange Commission, stating that Ripple violated the securities laws, highlights the reasons why the court should issue an injunction and a disgorgement. Because Ripple's primary business still involves the sale of unregistered XRP coins, the Securities and Exchange Commission believes that the injunction would be justified if it were issued by the court to avoid further violations. As Ripple plans to release additional unregistered crypto assets, the Securities and Exchange Commission asserts that the recently established business structure of Ripple may be connected to potential future violations. In the document that was submitted to the court, it is stated that Ripple has strong incentives to sell XRP even if its actions violate the law. This is further demonstrated by the fact that it has boosted its on-demand liquidity, ALES, even after the Securities and Exchange Commission sued it over those sales. As a result of this line of reasoning, as well as Ripple's failure to accept wrongdoing and the perceived shifting of blame, the Securities and Exchange Commission has requested injunctive action. As part of its submission, the Securities and Exchange Commission SEC has expressed its opinion that Ripple's assertion that there has been no financial damage to investors is inconsistent. Pecuniary harm can occur when disclosure failures lead to inflated prices, the Securities and Exchange Commission advises. It goes on to suggest that even if they made a profit by purchasing and selling XRP, they would still have experienced a financial loss due to the artificially inflated price because there was a lack of sufficient transparency. Injunctive relief and disgorgement are both likely to be granted. He recognized that the court may follow the example set by eFresh and determine that the institutional investors in Ripple have experienced financial injury. However, this is still highly implausible by doing so. He brought to light the inconsistencies of the Securities and Exchange Commission SEC when it relies on a case that is not legally binding to substantiate its case, but the SEC itself defends its disgorgement without providing any actual proof. Nevertheless, even though Medelman is critical of the SEC strategy, the court filing demonstrates that the SEC's objective is to prevent future violations using injunctive relief, as well as the enforcement of fines and penalties that both punish and discourage future violations. In addition, it underscores that the SEC is determined to hold Ripple accountable for its activities and how it failed to provide appropriate disclosure standards during its commercial transactions. At the end of the day, the outcome of this case might be extremely significant for the cryptocurrency industry in terms of the SEC's approach to regulation. The community of cryptocurrency enthusiasts and legal experts is paying close attention to the activities that the SEC takes about this controversy. The Ripple counterattacks and their concentration on the international community, Stuart Alderodi, chief legal officer of Ripple, stated in response to the position taken by the SEC in the appellate brief. He claimed that the credibility of the regulator is continuing to deteriorate. He observed that overseas financial regulators who have established sound regulatory frameworks for cryptocurrency could be perplexed by the SEC. In his criticism of the SEC's enforcement of regulations, Mr. Alderodi lamented the agency's lack of uniformity. On the other hand, analysts anticipate that a definitive verdict will be rendered sometime during September. He expressed hope regarding the result of the XRP litigation. In the meantime, the information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.